All right, welcome everyone. Thank you for joining us. It is a pleasure to have you here this afternoon to discuss an issue that TWA and our membership hear quite a bit about in our education and outreach and our issues and advocacy programs, and that is renewable energy and renewable energy development in the state of Texas. It is my great pleasure to have Laura Bowen with Braun and Gresham join us this afternoon to speak about this subject. Laura is a fifth generation Texas rancher and attorney from Winkler County. Seeing a need to bridge gaps between attorneys and rural landowners they represent, Laura strives to help landowners understand all contracts touching and concerning land, as well as negotiating to secure the best compensation and protections for future generations. Having worked alongside her family for years, Laura is uniquely suited to understand landowners' needs. She holds an advanced degree in agriculture and applied economics from Texas Tech, as well as a law degree from Texas Tech School of Law. Laura, thank you so much for joining us this afternoon, and I'll toss it over to you if you'd like to share your screen.
Perfect. Thank you very much for the introduction. I am very happy to be here and speak with TWA today. When TWA had reached out, such a big conversation is happening in Texas now. What about renewables? Is it right for me? And the problem with renewables is these leases happen primarily in closed rooms. These are subject to confidentiality. And so I have found education has been a big part of my practice, because unless you have been presented with a lease, you may not know what to look for, what to expect. And this presentation today is going to give you some early guideposts. If somebody does approach you, if this is a conversation in your community, these are the things that you need to watch out for. I do have quite a few cautions in here of things as a landowner that you should be thinking about to protect yourself. And I want to state for the beginning, I really appreciated my early conversations with TWA. They asked a lot of really good questions that I'm going to answer here in the time that I have allotted, but I certainly will not be able to get to everything. My presentation topped out at about 50 slides. I promise I'm not going to go over all of them. Andrew has graciously offered everybody that's on the call today, and TWA is going to get access to this presentation and some additional information I have, including these cautions. So please don't feel like you need to screenshot this. You will be receiving a copy of my presentation, so you can sit back. And I do encourage, I will be taking questions at the end. If you will put those in the chat here in the Zoom, I will get to as many of those as I can before 1 o'clock. So Andrew introduced me already, but I want to say again, I care about this subject because it touches and concerns me. I grew up on a ranch in Winkler County. You can see me here on a horse with my cousin. I also care about TWA. We have some fun roots with TWA. This is the biggest non-typical mule deer shot in the state in, I believe, 1991. If you are a UT fan, this little boy over here on the right-hand side, that's Colt McCoy. And so his father, Brad, shot this deer on our property. And funny enough, that property that you can see here, me and my dad working cattle this summer, in the background where that arrow is, you can see the No Trees Wind Farm. So this particular property, in early days when we were approached, and this is where a lot of my passion comes from, at times it didn't seem right for us. At times after it was built, it didn't seem right for us. However, it's in, and there's certainly protections that the industry will accept now that landowners, you should be pushing for. And that's what this presentation covers. What should you ask for that we didn't ask for? How can you better protect yourself? So we have the No Trees Wind Farm. This is another view. It's aptly named. There are no trees where I grew up. We are also host to the Phoebe Solar Farm. This is also in Winkler County. So I've seen it from both sides. We are dealing both with the wind farm and a solar facility. So I share both my experiences and my experiences as an attorney. At this point, I've seen hundreds of wind and solar leases and worked on over 60 distinct project groups all over the nation. So I've seen a lot, and I can tell you each one is different and unique because each property is different and unique. So Before we get started on the lease, I want to answer a question that I get most often. It's, why are we still talking about renewables? I see them everywhere. Don't we have enough power? And the answer is unequivocally no. We do not have enough power in the state of Texas. Now, this growth comes from many different sectors. Not only is it California coming here so they don't have to pay income tax and people coming for our favorable business stances, but we also have quite a few new industries that are coming in. So I do have a quote from ERCOT. Essentially, it says, we need all the power that we can get. And this graph shows it in some more detail. This right here is 2024, the year that we just left. This is the power that we needed to supply the grid to keep us from having blackouts. Here's where we are in 2030. We need a significant boost in power generation over the next few years into the end of the decade. And this is not because we're just getting more people. This large bar down here is base load. We also have crypto mining, data storage centers, the potential for hydrogen market, and then the electrification of the oil and gas sector. I was joking with a colleague earlier. I've been to 3 presentations in 3 weeks about electrifying the oil field. Some of that's going to come from renewables. And this morning, I also read a paper about it. So electrification is coming to many different industries. And certainly what people are looking for that are using power is cheap power. We're going to take all that we can get in Texas, and that includes renewables. So what to keep in mind is Texas is a mixed grid. At the end of the day, the all of the above approach, that's going to include natural gas. There are quite a few natural gas plants that are slotted to come into Texas in the remainder of the decade. If you look at these bars here, if you can see my pointer down at the bottom here, this is all our dispatchable power. So you hear the conversation, dispatchable versus intermittent power. Dispatchable power comes from a source that can be turned on and off in, somewhat of a truncated timeline. So natural gas spool up maybe 45 minutes. You can put online a facility to create power. Coal, it's a little bit longer. My understanding is about 8 to 9 hours. Nuclear can be turned on, but I'm not as familiar. And then, of course, we have wind and solar up here at the top. These are intermittent power sources. Essentially, if the wind is not blowing, the sun is not shining, we don't have these power sources. However, when we do have them, what it means for the grid is cheaper electricity prices. We have available power. You as the end user of that power get the benefit of this intermittent power on the grid. Wind and solar also especially shines. If you can see here, we have the afternoon hours, so 4 to 8. You can see we use a lot of solar power and a lot of wind power. Why is that in Texas? Well, that's when we all are running our air conditioners. So right here is where wind and solar has continued to shine and keep prices down on the Texas grid. So why Texas? Again, why your particular land? It's because ERCOT, the grid operated by the state of Texas, continues to be the cheapest and most attractive place for companies to build a project. What I mean by that is from the moment they approach you to the moment they put a shovel in the ground, there's the least amount of regulation, the most favorable outcomes for that price of that electricity, and the most land and available resources. So Texas remains the gold standard for where to site wind and solar facilities. At the end of the day, these companies do want to make money. They are going to get funding from the federal government. Maybe that's going to go away. In my personal experience, and looking at this industry over the last 20 years, just because the federal funding goes away doesn't mean these companies go away. It just means that the wildcatters and the bootstrap people go away. But the tier 1 companies, the people that have some forecasting and planning and deep pockets, they're likely to remain and continue to put in any sort of resource to put power onto the grid. I have a map here of the ERCOT marketplace, the counties that they serve. You'll notice Lubbock is in. That was a big deal about 10 years ago. If you're on the southern side, you're in MESO, you're going to be subject to federal regulation. If you are to get a wind or solar facility, it becomes more complicated. I can attest these are harder projects to put in. Same thing up north, you're going to be in SPP. and again, subject to federal regulation. Some of the timelines that I'll talk about in a minute, those extend out from maybe 3 to 7 years to get a project in Texas to 7 to 10 years. It starts getting much longer and much more complicated. The second thing that Texas has a lot of, even though we desperately need more, is available transmission. I have this good graph here. There's a line right here. These smaller poles, those are distribution lines. Those are going to go from a source to your house. We cannot turn around and put electricity onto those. We have to have some sort of transmission line, which of course this is the 345, the very big ones. If you see one of these near a property you're looking to purchase, or you see one in your backyard, renewables may be close behind. These are 138 in two different styles. 138, yes, you can still inject electricity, but it's less favorable. There's not as much electricity that you can put on it and take to a hub. And then lastly, you have 69 kV. Very unlikely that you are going to see any sort of renewables located next to a 69 volt line. They just don't accept much electricity, so it'd be a smaller project. So if you're looking at a piece of property and you see one of these transmission lines, you start to think in the back of your mind, this is a potential project site. So if you're looking at property, keep that in mind. If you don't see any of these poles anywhere, what I would do is go and look at ERCOT and the PUC and see if they plan to put one there, because they are, as I mentioned earlier, really pushing to add available transmission throughout the state, and especially West Texas. Again, I mentioned we're electrifying the oil and gas field. There's a lot of talk about additional transmission in and around that West Texas area, everything west of Abilene. So that's the why. And now I want to talk about the lease. So I have about 2 hours that I can condense down as quickly as I can about what's going to happen when you're presented with a lease form. The most important thing that I tell people is remember that you are in the driver's seat. It's an affirmative statement. Renewables companies do not have eminent domain power. I don't anticipate them ever getting eminent domain power, anything close to eminent domain power. They are asking, can I come here? Can I use your property? Can I build this renewable facility? We're going to talk about wind and solar, but also keep in mind batteries are a big part of the conversation now. So I'll use all these terms interchangeably, but they do have to ask you. So when they are asking you, what should you have in the back of your mind? First thing, who has contacted you? So there are companies that will go out and hire somebody local, which I like, that will go out and sit down with you at your kitchen table. They're going to bring you information. They're going to bring you maps. They may potentially bring you a lease. They're going to bring you documentation about who they are. They're going to talk about potentially other projects that they have in the area, or other, flagship accomplishments that they have achieved in ERCOT or elsewhere. Ask those people questions. Even if they bring you a shiny presentation, that's going to be your first point of contact with the company. You should inquire and ask every question of them, and they should answer. Now, on the troublesome end, I also have people who get mass mailers. If you get something in the mail and your name is misspelled, or it's addressed to your grandmother who passed away in 1950, that's a red flag. That company has not done research into your area. They haven't at least looked at the title record, or they're going off old information. And that's my first caution. If you are looking at something and it's unclear who it's coming from, if it looks like a mass mailer, that's when you need to start asking hard questions of this company, because certainly these projects are difficult to get in. You deserve to have somebody look you in the eye and talk to you about this project. Always encourage people, look at email handles. If you are being approached by ABC company and the person you're emailing with is from XYZ company, you need to start asking for the company that's actually going to do the development. I want to speak to your boss. I want to speak to your boss's boss. Have those people come out, talk to them, look at you, and pitch this, because it is a pitch. I also caution people, first, I am an attorney. Do not sign anything. without at least thinking about it and reading it several times. Don't sign anything at all, ideally. Once you start signing things, there's potential for you to be an obligation to negotiate with a certain company, have obligations of confidentiality. You need to look at everything presented by the company before you start entering into a serious negotiation with them. If you have a one-page mailer with your name misspelled, you can call the company and ask, what's your lease? What's your financial terms? What's the mats? Who else are you talking to? They may not give you answers to all of that, but that tells you something, how willing they are to work with you, how willing they are to negotiate. My big caution, and the question I'm asked also quite frequently, isn't there a producer's 88 of these forms? Won't I know what to expect? Don't you, myself, or Bowen have a producer's 88? Definitively no. Across the industry, everybody, all the big companies, they have their own form that they like. Now, they typically follow the same pattern, but with some big deviations. But as you move from company to company, just because you've dealt with ABC before doesn't mean XYZ company is going to have the same lease or the same terms. There is no rider that I can put at the end of it. It is a soup to nuts. I have to read every period, every line, and confirm that there's no hidden gems in there and take those hidden gems out. There is no producer's 88. So you are required, you should read every word of it. And if you don't read every word of it, you need to call somebody who's going to read every word of it for you and take out anything that is overburdensome. So I always advise people, sometimes companies will approach and they say, oh, we've got to do this now, or you need to sign a confidentiality agreement now, or you need to sign this letter of intent now. Nothing is that on fire. This industry is shockingly slow. It'll take 5-6 months sometimes to negotiate one of these leases. It's not like oil and gas. This opportunity is not going to vaporize over a weekend. You have time to talk to your family. You have time to talk to your heirs. You have time to talk to your neighbors if you have a good relationship with your neighbors. And I advise you do all of that before you enter into any sort of written agreement of confidentiality. If you have no obligation to that company, you can freely discuss what the issues are and whether or not this is something that's going to make sense for your area. I also advise, again, grain of salt, I am an attorney. Talk to your attorney and also talk to your CPA. Depending on the size of the project and the size of your land, this can be estate-altering amounts of money if it goes through. And so you potentially need to have a plan in place to accept this influx of cash into your property or into your entity. I'm going to get also into some key lease terms. This is where we get into the word salad of my agreement. Again, please don't feel like you need to read every word here. I'm going to overview it and mail this to you later so you can read it at your leisure. For both wind and solar, when we're looking at the lease, one of the first questions, Laura, how long is this going to be? Average still is about 25 years from the date you sign to the date they take it out, to up to 60 to 70 years. I don't like anything to go past 50 years, but there are some exceptions. So we're in this range. This is generation spanning. You need to understand at each phase what is happening, because the first thing that's going to happen is a lot of nothing. They're going to approach you, negotiate a lease, and then they're going to enter into an option or development term. Again, depending on which flavor of lease these people use is how they're going to style it. But essentially, it's a number of years, typically 3 to 7, where they have access to your property, and there's going to be people out doing studies, but they aren't building anything on the property. They aren't altering anything on the property. And most of the time, they won't be there. So typical studies are going to include wildlife studies, surveys for special architectural sites. They're going to do surveys of the property. Again, if they lease you, they very well can't put solar accidentally on your neighbor. You'll get a nice shiny new survey as part of the typical development package. They're going to be out there, potentially putting in a sun measuring station, a wind measuring station. They're going to be out on your property, but it's minimally impactful. Once construction starts, that changes, especially if you're in solar. Once solar construction starts, you're out. They are going to tell you, okay, kick out your tenant, take off all your stuff, move your deer blind, hand over the keys, at least to that solar area. They're going to be in that solar area constructing, and this is, depending again on the size of the project, potentially very invasive. There's going to be, sometimes hundreds of people at one time out putting up this project as quickly as possible. Time is money. The quicker they can put it in and get it operational, the better. So they're going to have significant construction out on the property for solar. For wind, typically because those big turbine blades, obviously you've seen them on the highways, they don't take 90-degree angles very well, and they don't take stopping and starting very well. So they're going to go out and build a nice shiny road out to that wind turbine site and bring those turbines in. Typically, they're going to want to keep the gates open. So they may request, okay, you need to stop hunting, you need to move your cattle. As to this area where the road is, you're going to lose access to those crops, or we're going to plow them out and put that cliche road over the top. You can handle all of that and that process in the lease term, and you should make some specifications, especially if you have something very special out on the property or certain places you do or do not want them to be. But it's still invasive, whatever way you slice it. Then we go into the operations term. For wind, it goes back down to minimally invasive. The turbine is in. From each turbine, as we go back towards a central hub, there's a road, and then there's a collection line. The collection line is about a fist in width, and it's buried typically at 3 feet. It's going to be covered over, and you'll lose track of it. Sometimes the companies lose track of where it is. You should ask for a survey of where those lines are so you don't plow them up. But it's minimally invasive. You aren't going to see people out on the property, typically day over day. Solar, again, though you can't go in the property, there's not typically people walking it or tracking on it on a daily basis. Most of those are operated remotely. And so long as the fence is really good and there's no issues, you may not see people, but for occasionally. So those are the terms. Again, if you start seeing a 99-year lease, that's far too long. And that's not necessary for the industry. I'd toss it or make a solid counteroffer. The next thing I want to talk about, again, hot topic always, what are they going to pay me? An unfortunate answer for everybody today is it's too region specific for me to get into. The numbers would be, I think, silly if we go from our range, what is West Texas to East Texas, MISO, SPP, ERCOT. At the end of the day, you need to remember the value of your property for other uses. So if we have, potentially dry ranch land, we'll pick a county, Pecos County, and you don't have a lot of other legitimate uses for that. It's not going to become the next Camp Lucy. Nobody's maybe going to pay to go glamping there. It's not going to be as valuable. Your solar lease or your wind lease is not going to be as valuable if maybe you were in the picturesque hill country where you have potential for other commercial developments or monetization of that project, especially as the cities move out. Dallas keeps getting bigger. Austin and San Antonio is just city the whole way. If you have potential for that site to also be a Buc-ee's, you're going to get paid more for your wind or solar lease because they have to then monetize what you would have lost if you had put it into a Buc-ee's or, pick your other commercial development. Payments also, again, are going to depend largely on the company, how those are structured. Most typically for both wind and solar leases, for that development rate, it's going to be a fixed price per acre. That's why your Exhibit A is going to be very important. Make sure you look at your Exhibit A. You will be paid based on the number of acres listed there. That's typically pulled off your deed. Construction term payments, this is when we start going in different directions. It's going to depend on whether they're paying you on the proposed project that they're putting in. If you've had an attorney like myself that argues as soon as you move in a solar facility, I lose all value to that land, you're going to pay me my high rate immediately. That's what you want. Potentially it's a lower acreage rate. And then for operations term payment, again, it's going to depend on wind or solar, how you're paid. So for wind, most typically you're paid one of 3 ways. So greater of a price per acre. So Exhibit A times rate, or a payment per megawatt installed on the property. So a wind turbine, if you're driving around the state, if you see an old wind turbine, it looks old, looks small, it's probably 1 to 2 megawatts. That's where we were about 20 years ago. Now the wind turbines that are going in, typically 3.5 to 5 megawatts. They keep getting bigger, they keep getting more efficient, but it's going to matter. And you should ask the question, company, what size turbines do you plan on putting in? Because my lease says this price per megawatt. And if you don't know the megawatts, you are missing a part of that equation in calculating what your potential revenue is. And the last thing is wind, traditionally and continued payment on gross revenue on the project. I'm seeing us, potentially start to shift away from this, which I don't like. Wind is typically sold on the open market, and so you can get the advantages of sharing in that gross revenue. The percentage is going to be based again on the company and where you are in the world, but all of those payments should go up every year, or in some cases every 5 to 10 years with a big bump. So payment for solar is a little bit more straightforward. There is going to be a fence, and inside the fence, you're going to get paid for those acres. With some caveats, again, this is where you want to be really careful when you're looking at your lease, because there may be acres that don't physically have a solar panel on them, or inside that fenced area, and the company says, no, goes, I don't want to pay on that because I'm not making money off of it. You need to guard against that. And then there also may be acres that are outside of the fence, but not accessible, that you may not be paid on. You want to be paid on everything that you then lose access to. It can be a big fight, but there's certainly different compromises that have been made to protect essentially a landowner. If you can't use it and the company can't use it, it's the company's fault. Go make them pay for it. In addition, less likely in a solar lease, but typically with a wind facility, you are going to get paid on additional surface damage. So not only that location and that acre or 2 acres that you're losing for the turbine base, but roads and collection lines and other big facilities. I could do another hour on substations and switching stations, but when you start looking anything else that's not a wind turbine that they have the right to put on your property, you need to start looking for a damage payment for that, either a price per square foot or a fixed price, or some consideration for them taking it out of whatever use it's currently in and putting it into their use. So that's how long and how much they're going to pay me. And then we get into the meat and potatoes of the rest of these agreements. Now, I think I mentioned, it's worth mentioning again, these leases are just a slog. I looked this morning. My shortest one was 27 pages and my longest one was 54. That's on my desk this morning. 54 pages, single space, 10-point font. There's a lot of words in there, and surprisingly, most of them are necessary. There's going to potentially be some things that you want to pull out, additional grants, and that means, and they may not be titled, we have the right to purchase all of your property for $5 an acre. That may be buried somewhere in there. That's not from real life, by the way. But they may have something buried in there that you are going to want to make sure that you get out. And it may be titled as something else. So you do need to read these word for word. One of the best places to start is the granting clause, just because it says at the top, this is a solar lease. Solar lease. Our intention is to put in solar. That doesn't mean that in your granting clause, you aren't giving up more. So the big ones that I typically see are some grants of the water estate or water rights. Take that out. If you don't want to sell them water, fix a price or something. It's a solar lease. It's not a water lease. The other big one right now is battery energy storage. It could be listed as BEST. It could be listed as energy storage or similar facility. Any sort of language like that is a different conversation. It's not a solar panel or a solar facilities of pertinent parts. It is a separate facility. It's a BEST system. So potentially that needs to be under a different valuation or a different lease. Do not let them have a laundry list of things in there that they can build. You need to tighten all of these agreements down to what actually the intention is to build a solar facility, to build a wind facility. Also note some ambiguous language. Sometimes there's future technologies, so it's solar or future technologies. I really hate that language. It should be solar photovoltaic facility. That's a solar panel. I'm giving you the right to build solar panels and nothing more. You should also read everything, but really make sure that you read your covenants and your reps and your warranties. So a covenant is going to be something else. So we have the right to build solar on your property, and you're providing, landowner, you're providing a covenant for us to build something or to not build typically something else. So if you're building a solar facility, now this is a reasonable ask. I'm building company building a solar facility. You are then typically going to see in your lease a covenant not to build skyscrapers around the edge of their solar facility and then shadow that solar facility. So it's going to be a negative easement or a covenant not to interfere. You can then start to limit that. And that's going to be really important if you have, say, 10,000 acres and 1,000 acres is going into the solar facility. Watch very carefully for any sort of thing obligating you to do or not do something on all of your adjacent property. It's common because, companies, they want to protect themselves, which is fair. However, they do not need access and they do not need covenants and they do not need any sort of restrictions on that remaining 9,000 acres. There's some limitations and some compromises that can be made there, but shrink down their footprint and make sure you know where they're supposed to be. And representations and warranties, again, very important. Typically it reads, I, landowner, represent and warrant that X is true. So some of these are going to be knowable to a property owner. So for example, I own the property. So if you have the deed, you know that you own the property. I wouldn't represent or warrant anything as to title in the past. That's going to be something you want to put a limitation on. Some of the things too that they ask you to represent and warrant are completely unknowable. The best example I use will go back to Pecos County. It's a place of historic oil and gas production. We've been a century. We don't know what they did in 1920, and you may have bought this property in 1980, and companies asking you to make a representation that there have been no unrecorded easements, no underground storage, no hazardous materials out on that property. Immediate red flags. You don't know. You bought it in the 80s. You can make a representation that you have not gone out and buried a bunch of asbestos in the back 40. You can make that representation because you know whether or not you did that. But whatever everybody else did before you take it, do not make any representations as to what those people did because you just don't know. Even if you have a really great idea, I still would take that representation out. The other big one, and this has become a bigger and bigger conversation, and I'm going to put a fine point on this. Whoever approaches you is not necessarily the person or the company that's going to construct the project and operate the project. Typically 5 to 10 pages of the lease are dedicated to company's ability to assign it, to sell it, to mortgage it, which they're probably going to mortgage it because it costs a lot of money to put in the facility. And you have to protect yourself during that process. It's going to be potentially titans against each other, big companies, big corporations. How are you as a landowner going to protect yourself in that process? If you have good negotiating power, you can start to get things like, I get landowner approval before you assign this, or if you assign it, it has to be somebody who is qualified to operate this project, has experience, has the liquidity or the capital to back this project. But certainly I see also the flip side of that. I represent a lot of people that are getting small portions of projects, or their neighbors have signed leases and they're in a bad negotiating position because everybody else did it, sign it without hiring an attorney. So I'm fighting against what everybody else did. It's important, again, stop and have these conversations. How are we going to protect ourselves as this project potentially moves around? I can attest the first person that you sign that lease with isn't the person that puts in the project, and then isn't the person that buys the project. That's 3 different companies that you have their names. If you have an issue, if a gate's open, who are you going to call? So you can make specifications in your lease form. You have to let me know who you're selling this to, and I need a local contact, and I need you to inform me in writing before any of these things happen. Typically, a company will agree to do that. Quickly running out of time. So I will just state again, property tax becomes a bigger concern with solar. It's very likely that you're going to lose your open space valuation. For wind, not so much, but I've heard rumors out of the panhandle that some of the taxing districts out there are weaponizing property tax against wind turbines. I haven't seen it personally. I just hear the rumor mill. Suffice it to say, company needs to cover any additional tax that you incur, and that includes rollback, which right now is 3 of the 5 previous taxable years. That's a lot of potential rollback. I mean, it can be to the tune of millions of dollars. I've seen some of these bills. Company needs to cover it. You can also make specifications for your insurance. Again, if you have a big operation on the property or valuable things, exotics, or you're operating something like Camp Lucy, some sort of big facility where you have people coming on and off, you want to look at things like your umbrella coverage and ask for more insurance to protect you in case there ever is an issue. I'll just suffice it to say, other things that you do on your property, all of that can be accommodated. So grazing, hunting, your farming, your house, your wetlands, your roads, your entrance, your shiny new entrance, no wind turbines going in there, they'll scrape the top, perfect. Give them a different gate. And you can get very unique in this. I have 3 funny examples from real life. I did have a client with a historic rock wall. The company, we got them to agree they're going to hire an engineer and somebody to move that rock wall closer to the house and out of the solar facility. They're very happy to do that to keep the clients happy. I've also mapped and accommodated, I think it was several hundred by the end, different blinds and deer feeders, setting back the wind turbines from their favorite hunting areas. You can ask for that. The worst the company can say is no, and the best they're going to do is pay for it and take care of it, and be penalized if they're harming your hunting. So definitely ask. I've also excluded wind turbines from Mama's view from her kitchen sink. We had the surveyor go out and walk around with a balloon, red balloon on the end of a string, and we set back where she would not see any of those blasted wind turbines from her kitchen window. You can ask for it. You're in the driver's seat. If you have specifications or concerns, bring those up and make sure it's in writing. It's not real unless it's in writing in your lease form. Certainly ask, see if you can work something out. Both wind and solar are subject to removal bonds. This is by law. So anybody here that has is presented with a wind or solar lease, this removal bond will be in there. It's going to require that they take out everything to a depth of 3 feet. That's going to include substations, concrete footings. That 3 feet is negotiable, but it's a hard negotiation. And then they're also going to post a bond. This is going to be money in a third party that's posted for your benefit in the event that the company goes bankrupt. So first, they're required by law to remove everything. In the event that there's an issue, company doesn't do it, you then have money for you to take those facilities out. In practice, we've seen some decommissioning of wind, and I have never heard of anybody having to draw on their bond. So that's good as of 2025. I'm going to skip oil and gas. We will just look at the pictures. It's possible. Here is a solar facility in West Texas in the Permian Basin. You'll see a bunch of holes in it. Those holes are old oil and gas wells or existing oil and gas wells. You can see where the pipelines go through. At the end of the day, especially if those facilities are already in the ground, great. You know where they are. You know they comply with spacing. You can put solar around them. With wind, it's a little bit easier. This is Panther Creek south of Big Springs. You can see a lot of the oil and gas production in the area and the roads, and you can see how wind, there's a lot of space on the surface, we can slot in and around existing production. The important question to ask is how much of the mineral estate do you own? And is there any representation or warranty that you own all of it when you don't, or that you're going to accommodate those third-party mineral owners? Every third-party mineral owner, any sort of interest that you do not have in the mineral estate, always advise, treat it as hostile. You don't know what those people are going to do. You don't know if they're living in a van in California and think they're going to get a windfall like Jed Clampett when they find out they have minerals in West Texas, and you are going to cover them up with solar. Be very careful of these people. How do you accommodate them? How are we planning for future drilling? And all of that should be at the company's time and dime. They need to pay for it. They need to find them. They need to do the title report, because you don't know. They need to go find out. It's their homework. Last, I just want to say again, this is not oil and gas practice. I have a lot of people that come in and say, okay, you know, in a week, we're going to get this done. I think my shortest lease negotiation was about 3 weeks, and that's because I'd already negotiated the form many times before. And my longest topped out at about 2 years. It takes a while. Average is 5 to 6 months. There's going to be a lot of details that should be worked out. We may be out there with a surveyor with a balloon, a red balloon on the end of the string, and making exclusion zones. We may be arguing about qualified assignees for the project. We may be arguing about how they're going to pay you for crop damage. It's worth it. All of those things are going to impact you in the future, and it's important to get it in writing and get it done the first time. If you're going back and having to amend it, or you're going back and trying to say, well, you know, so-and-so said that y'all would take care of this, you're on the back foot. Be proactive. Make sure everything's in writing. Remember, everybody that talks to you on the developer side, they're salesmen. They're going to paint a rosier picture. You know, you can read the internet, potentially Facebook, and see the worst case scenario, but the truth is typically somewhere in the middle. So I wanted to cover, considering the audience in the last few minutes, 2 questions. One, can I keep hunting? And the answer is, lawyerly, it depends. Can't hunt in a solar facility, that would be bad news. And you need to be very careful around your solar facility. Sometimes we talked about covenants. They're going to say that you can't hunt around their solar facility. Okay, what's around or adjacent to? So you need to start setting distances, you know, within 200 yards of the solar facility, or however or whatever makes sense for you. Within the solar facility, please do not go in there and shoot your gun. That's a bad idea. And that equipment is very expensive. But outside, especially as you're moving away, that is still open for hunting. Wind, again, wind goes from very few people on the property to a lot of people on the property to very few people on the property. It's important that notice is given, because you're going to potentially have company people out there. If they're coming out there during the peak deer season, you're potentially going to have a problem. So you can start saying things, okay, this is deer season. During deer season, all operations besides emergencies are from this time to this time. You have to call and give me 24 hours notice. If there's an emergency, you have to call me immediately and let me know so I can notify my hunters so everybody can be safe. During construction, they typically tell you no hunting. However, you can start putting limitations on that. I have a varmint provision where we're talking about, okay, no hunting. We're not going to go rifle hunt, but we can still hunt hogs and rabbits and coyotes and alligators, because there was some issue with that in East Texas and I never took it out. So you can continue to varmint hunt, and these are part of the conversations. This is why it takes 5 to 6 months. And then last, I'm going to answer 2 common questions, and I'm going to turn it over to the chat. So what about the birds? So I put here this cute little kitten. He is the #1 killer of birds, according to Fish and Wildlife Service. The estimation for domesticated cats is about 2.4 billion, based on some dated, and I will say dated, studies. But when we're going down our list of killers, #1 right here, this cute little kitten, we also have skyscrapers and plastics and utility lines. And then when we start getting down to wind turbines, they hardly register on a pie chart. They absolutely do kill birds, and it absolutely is an issue. But what you have to remember is a wind turbine facility is going to be subject to the Migratory Bird Treaty Act, the Bald and Golden Eagle Act, the Endangered Species Act. They're a company, they are going to be subject to those takings, subject to the Bald and Golden Eagle habitat. They are required to do mitigation, and I've put some resources here, Texas and United States, and some of the requirements. All of these are clickable links, and you can go through and read about this in more detail. The point I always make is, yes, we do need to be cognizant of where we're putting these facilities in, and the companies are certainly cognizant of it as well. So we've seen, especially in Central Texas, we're talking about the tricolored bat. On the coast, we're talking about migrating birds. They are doing good work on facilities that attach to the turbine that can switch them off automatically if there are migratory birds detected in the area. All of these things come at a lot of cost and expense to a company, and I don't have to put in my cat when the cedar waxwings are coming through or any sort of bird is coming through, but certainly wind companies are held to a higher standard. And this is a conversation that I think people would be impressed, have this conversation with the good reputable wind companies. They're going to have a plan in place. They're going to be able to tell you what these endangered species are and what their mitigation plan is. Ask those questions. If you don't like the answer, then you can start asking whether or not this lease is right for you and your community. So I'm going to stop there and answer some questions, and you'll have quite a few. I'll answer as many as I can in the time that we have. So we covered mineral interest a little bit. I'll just note it gets more complex with solar than it does with wind. Everybody, was anticipating an apocalypse when it came to wind and oil and gas. At the end of the day, everybody seems to be able to play nice. We do have one court case for minerals and solar. At the end of the day, my professional opinion is that was based on bad title. If there had been some better conversations and some better title and some curative and some kinder words, I don't think that would have gotten all the way through to the El Paso Court of Appeals. Everybody else seems to figure it out. I've worked on a lot of accommodation agreements. These will be third-party agreements with existing lessees and the company to say, okay, this is the road in. Oil and gas company, we are going to give you, solar company, rights to use this road, but you're going to maintain it. These are our shared spaces. These are our well locations. Here's the plat. Solar, you can't be, within 1,000 feet of this super pad gas site. So it can be worked out, but again, this is part of why it'll take, 3 to 7 years to get sometimes a solar facility in. A year of this, in my experience, a year of it can just be finding and accommodating the mineral estate, finding and accommodating existing mineral lessees. I'm going to save SB 819 till the end. We'll talk about it. So say a company goes out of business year 10 into a 30-year lease. Again, this goes back to the removal bond statute. If you're at all curious, that is going to be Texas Utilities Code, Chapter 301 and 302. I'll say again, my professional opinion. The wind statute, it's a little bit better. It's a little more landowner friendly. The Texas legislature decided that in 2021, wouldn't it be great if we have a solar removal bond? So they just took the word wind out and put the word solar in. And now we have a law on how to remove wind turbines for the purpose of removing solar. So I do tweak that one quite a bit. You want to talk about things like putting back up interior fencing, additional protections for the topsoil, reseeding, where we see quite a bit more surface disruption. You can get into the literal weeds with that, and you should. I heard tell that potentially there's going to be an additional removal bond statute for batteries, which I say excellent. That's fantastic. However, please do not copy and paste the wind removal bond statute because it won't make sense. So if anybody's talking about that, please call me. I've got some opinions and that I would be happy to share. Last one is, what is the mechanism It's written into allow this 1031's exchangeable. Okay, this is even, oh, this gets even more into the weeds. We don't have time, I think, really to cover this, but the overarching statement is that 1031s are an exchange of property, whereas leases are an exchange, or it is a granting of a leasehold. So I hear on the periphery a lot of talk about exchanging these leaseholds. Get somebody reputable in and get a company that has dealt with it before. I've heard and seen a lot of people that think they know what they're doing, and they don't. So last was the likelihood of SB 819 passing. I don't know. I really don't. I think, based on my experience last time with SB 624, the question continued to pop up, what does this do to private property rights? I think those same conversations are going to happen again. At the end of the day, I want to point out some successes for communities. And my thought here that I'll close with is there have been communities that have banded together and made sure that renewables don't come. There is municipal zoning that can happen. There are countywide initiatives. There have been projects that have been stopped dead in their tracks because the community said no. And that's what communities should do. And I'm talking, on the county level. I think it is very important, again, to talk to your neighbors, to, have the buy-in of the people around you. This is what's going to make these projects successful. I get very nervous when we start passing laws that make sense for, or that don't make sense for, but obligate every single county in Texas to the same set of rules. I'm from West Texas. I spend a lot of my time now in Central Texas. I've done projects east, west, north, south, all over the state. I can tell you definitively each property in each culture and each community need is very different. And that's where statewide regulation starts to get tricky. And I think that's all the questions that I have. If anybody has anything else, let me know. Otherwise, I'm going to turn it back over to Andrew. Again, I really appreciate y'all's time today. Y'all will be receiving this presentation I've gone through, plus some additional cautions. As I said, it got too cumbersome. So now we're just going to ship all that information to you, and you can read it potentially tonight if you want to have something to put you to sleep. So thank you to TWA, thank you to Andrew, and thank you to you all.
Laura, thank you so much. This is such a tremendous wealth of information. I think it will be a great resource we're going to have this recording made available online. And as Laura mentioned, we'll have a version of this presentation made available to everyone on the call. I did have one question for you, just related to, I guess, partially related to SB 819, that bill, as well as there's another proposed that deals directly with battery storage, but related to property setbacks. And, some of those that are included in that legislative language, maybe could be described as ambitious. But a question for you is, how common currently in these are setbacks just as a good business practice on the landscape currently?
That's such an excellent question. So when we're looking at a project, and we'll put on our developer hat here. So you're going to put in an asset on a leasehold that, potentially is going to be in the, hundreds of millions of dollars. So if it's rough math, it's about $1 million a megawatt to put one of these projects in. Real rough math. But if you, company, are coming in and I have a $250 million project, for insurance purposes, for title insurance purposes, for best practices, companies I see over and over again, they have an internal setback from unleased landowners. So they're already going to set these things back far enough that if, say lightning struck it perfectly and it fell like a tree, one of these wind turbines, there's not going to be a chance that it's going to go over onto unleased property. That's very typical. Same with solar. I've negotiated many tree barriers, setbacks from unleased neighbors, best practices for these companies, because at the end of the day, if there is a physical trespass, that's an invitation for a lawsuit. They have spent too much money to be, living on the edge. There is no living on the edge with 300, $400 million projects. They're going to set it back. Maybe they're going to plant a tree barrier. In addition, companies are more, I'm seeing more and more neighbor agreements. So neighbor agreement is going to be a agreement that you enter into with the company. They're going to burden your property with a covenant not to build with competing wind projects. So that's one benefit for them. But they're going to give you a certain amount of money each year, typically a price per acre for the bother. So I've worked several of these recently. The company is very forthright. They say, you're in a bad position. You're by this road. You're by this house. But we know that you're going to be looking at this wind turbine. We can offer you this many dollars a year. Sorry for the inconvenience. So that is becoming more and more common. And I like that practice. Again, this is where the companies are policing themselves. But again, these are tier one companies. I'm sure that, and I've seen just not many, but I have seen some bad actors out there. Part of my job is stamping on those projects and saying this is a bad idea based on the community, based on the neighbors, and telling the landowner this is a bad idea and this is why. There's too many people around, or whatever the case may be. But excellent question, Andrea.
Well, thank you so much for your time this afternoon. I really appreciate you kind of laying everything out for our group and making yourself available. Again, Laura Bowen with Braun and Gresham. I would expect if anyone needs to reach out to you individually, they can find your information on the B&G website there, and or I'd be
And here,
glad to.
yeah, you're going to get a copy.
Oh, perfect. All
Okay.
right. Well, thank you so much, everyone. Thank you, Laura. We will see you back here next month for the next episode of Wild at Work. Take care.
Bye, all.